tí à ń gbọ́ awuyewuye tó ń lọ nígboro wọn kẹsẹ̀ rẹ̀ kúrò ńlẹ̀. Ní báyìí ẹ tẹ́tí sí ohun tí gómìnà tí wọ́n ní sọ. Títílọpẹ́ Ajíbóyè lórúkọ tèmi, ẹ máa bá wa ká lọ.
Okay. Well, if you are ready for me, let me know. Okay, call them. That's what I'm saying. Is he okay? Gentlemen of the press, you are welcome to Osun State Government House. I'm going to take my time to address you. I call this press conference the national global audience about a deliberate plot to create chaos and in Osun State. I invite you all to expose a faceless anti-democratic agenda designed to enforce a non-existing court judgment on our local government. Evil plot of marine to economy, Mr. Gboyega Oyetola, in active collaboration with Osun State Commissioner of Police, the Osun State Director of DSS, and the State Commandant of the Civil Defense Corps. Before I continue this address, let me affirm that I know Mr. President to be a true Democrat, a lover of rule of law, and a believer in sanctity judicial process. I know, as a matter of fact, that Mr. President will never authorize a dictatorial violation of the Constitution, irrespective of who is in. It is crucial to add that Mr. President will never support any action that is capable of generating bloodbath and bloodshed. I, however, regret to inform Mr. President and the public that Mr. Gboyega Oyetola has concluded an arrangement in Osun State starting from Monday, issuing directives to enforce illegality simply because he is nephew of Mr. President. I choose to allow the nation before my people are killed or maimed by a ministry, the name of Mr. President, in connivance with the Osun State security operatives obeying unlawful orders. The bone of contention is the brazen effrontery to return to office council chairman sacked by a subsidiary court judgment using a different court decision, which has no consequential order. Let me make it clear that the said council chairman was sacked before I was sworn in as governor of Osun State, contrary to the lies being peddled that the chairman and councillors were sacked by my executive order. For emphasis, I want to state that I had nothing to do with the sacking of the chairman and councillor produced by the Osun 2022 local government polls. The chairman and councillor were sacked by the two different judgments of the Federal High Court, Osogbo. The script Mr. Oyetola is playing is about the most reprehensible abuse of power in this false republic, capable of untold and unforeseen consequences on the polity. The general public is aware that there were two different federal high court judgments on the local government election of 22. The first judgment was on the suit filed by the People's Democratic Party (PDP), which sacked the product of the 2022 polls. The second judgment was on the suit filed by the Action People's Party (APP), which also sacked the chairman and councillor produced by the said 2022 Osun local government polls. The APC appeal against the judgment obtained by the PDP was partially successful, and the said judgment was struck out based on the timing of filing, having been filed before notice of election was published. It needs to be emphasized that the judgment contained no consequential order. The APC, in its amended notice of appeal, asked the Court of Appeal to reinstate the sacked chairman and councillors, but the Court of Appeal, in its wisdom, said it has become an academic exercise. The request for the reinstatement of the chairman and councillor was not granted. However, the appeal by the APC against the APP judgment did not succeed at the Court of Appeal, which makes the judgment still subsisting and alive. The Court of Appeal dismissed the APC appeal against the judgment obtained by the APP. The only legal recourse open to the APC is to appeal the APP judgment and the subsequent ruling of the Court of Appeal to the Supreme Court. 2 copies of both judgments had earlier been forwarded to the Osun State Commissioner of Police, the State Director of DSS, State Commandant of Civil Defense by Osun State Attorney General for their information and record. The certified 2 copies of both judgments are in domain. The judgment of the Court of Appeal on the PDP case was not ambiguous whatsoever. It simply struck out of the PDP suit and did not, in any of its paragraphs, order the reinstatement of the sacked council chairman and councillors. It is very clear that no consequential order was made before the APP case is still subsisting. As I stated earlier, the Court of Appeal said that the request of the reinstatement of the chairman and councillor has become an academic exercise. We call on legal luminaries and the Nigerian Bar Association to check our claim by reading and interpreting the judgment. Even as a layman can comprehend the meaning, except those with an agenda, peace and proof of but we should be satisfied with the outcome of a court process. We can appeal to the next court to end at the Supreme Court. If you are not sure of the meaning and intent of a court judgment, expect you to interpretation against it is unconstitutional and anti-democratic to take the law into your own hands. For a serving minister, the person of Mr. Boyko Itola, to lead charge to violate the Constitution and foment violence over a judicial process is not only shameful, but is sadism and treason taken too far. We have it on good authority that Mr. Boyko Itola has instructed the Osun State Commissioner of Police, the State Director of DSS, and the State Commandant of Civil Defense Corps to mobilize security operatives from within Osun State, effect the non-existing judgment by forcefully taking over the local government on Monday. Mr. Oyetola and the police boss have been holding a series of on how to effect the illegal operations. We affirm that Mr. Oyetola has no constitutionality to issue directive to the security agencies. The fact that Mr. Oyetola is nephew of Mr. President does not put such authority on him. We see this as a gross betrayal of trust reposed in the Osun State security officers by the Constitution of the Federal Republic of Nigeria. I want to state that the current nefarious activities of Mr. Oyetola and bosses of Osun security constitute great incitement. This need to stop because we are neither interested in resorting to self-help nor in support of to resolve good matters. As much as we are law-abiding people, we are fierce protectors of our rights at night and by the day. I want to place on notice the Nigerian public and our friends in the diplomatic community and the lovers of democracy and rule of law that our people will not accept any attempt to impose illegality and anarchy on us. We will not allow any takeover of local government except through a judicial pronouncement or we vehemently reject any ploy to deploy non-existing court order to achieve local political power. We reject any to deploy any existing court order to achieve political power. I therefore appeal to Mr. President, who is a renowned Democrat, to insist on the rule of law by instructing the Inspector General of Police, the Director General of DSS, the Commandant General of Civil Defense Corps not to an illegal order from his nephew, Mr. Oyetola. The Osun State Security Chiefs should also be called to order. I call on Mr. President to instruct the National Security Advisor and the Attorney General of the Federation to personally verify the fact the Court of Appeal judge local government chairmen and councillors, and the fact that there is a subsisting judgment of court that sacked the chairman and councillor produced by the 2022 local government polls. The Nigerian public should hold Mr. Oyetola and the Osun State security chiefs responsible for any breakdown of law and order in the state tomorrow. Monday and beyond. It is unfortunate that the Osun State security chiefs are taking instruction from Mr. Oyetola just because view of Mr. President. It is not acceptable. As much as our best to maintain peace, call men and women of goodwill to intervene before it's too late. I repeat, as much as we will do our best to maintain peace, we call on men and women of goodwill to intervene before it's too late. And for listening. Now, I will call on my Attorney General, Mr. Bada, to further explain and expatiate before my of information we address you to. Over to you.
Thank you.
ẹ̀yin ará ilé ọ̀rọ̀ lẹ ti gbọ́ láti ẹnu gómìnà ìpínlẹ̀ Ọ̀ṣun yìí ẹ jẹ́ ká gbọ́ láti ọ̀dọ̀ attorney general ìpínlẹ̀ Ọ̀ṣun báyìí.
For us to look at the judgment of the Court of Appeal that some people are interpreting wrongly. Page 34 of that judgment containing the 4 issues for determinations that was before the Court of Appeal. And at page issue 1 deals with the amendment that the before suits on now, since it is the position of this court that there is no valid originating process to confer jurisdiction on the lower court to hear and determine the claim of the first respondent, there is no point in considering the remaining issues. A consideration of the 2 remaining issues has now become an academic exercise, which this court is not prepared to venture into. The 2 remaining issues not considered are the issues on restated, sacked, and cancelled at the federal high court. Not considered because it is academic and is not prepared to venture into same. The Court of Appeal went further. In the circumstances, the resolution of the 2 issues in favor of the appellants. In the circumstances, with the resolution of the 2 issues in favor of the appellants, it follows that this appeal is meritorious and it is accordingly allowed. The amended summon is hereby struck out for incompetence. Suit number C/OS/CS/94/2022 and is hereby struck out. Cost of 250,000 to the appellant against the first respondent. The implication of this is that the suit filed by the PDP was struck by the Court of Appeal, and of course, by implication, the judgment, of course, was also struck out. That means PDP never brought any action, and there was no judgment. There was no order, no consequential order, or the Court of Appeal did not even consider the issue that borders on restating the sacked chairman and councillor. It was never considered by the Court of Appeal, and there was no order in respect of those issues, because according to the Court of Appeal, it is academic, and they are not venturing to save. So the nation now is that the chairman remains sacked, the suit is struck out, and the judgment, of course, is also set aside. But now it is expedient at this point that I refer the House to the Federal Court decision in F suit number FHC/OS/CS/103/2022. Action People's Party and Independent National Electoral Commission, INEC, and 6 others, wherein the Federal Court held thus at just 1 minute. It was a judgment in rem, where the Federal Courts at pages 47 to 48 held us. Furthermore, in the exercise of the power conferred on me by section 6(a) and b of the 1999 as amended, I hereby make the following consequential orders. 1. The election into the local government council across Osun State held on 15/10/2022 pursuant to notice of election issued on 15/8/2022 is hereby declared unconstitutional invalid, null and violation of the Constitution, and breach of sections 28, 29, 32, 98, and 150 of the Electoral Act 2022. Then 2, all offices in the state law council by valid election are attacked from holding such offices. 3, sections 25 and 26 of the Osun State Independent Electoral Commission Law 2022 having been enacted in contravention of paragraph 12 of the part 2, second schedule to the Constitution, and being inconsistent with section 29 and 32 of the Electoral Act 2022 are here struck down. They are above this court. Now, the judgment in rem that everybody, including all political parties in Osun State and even Nigeria, are eligible to participate in the election, election of 2022. It is a judgment in rem, and it is still subsisting. And also, of course, it is also that I also draw the attention of the gentlemen of the press to the decision of the Court of Appeal on the 13th of January 2025 that still by the always saying that something is no decision of any to is public. But I also want the gentlemen of the press to also take note that assuming there was any order, the beneficiary of the judgment knows what to do. They will appoint the courts to try to enforce it by bringing the contempt proceeding against whoever that is stopping them from enforcing same. So if at all there was any, they should not resort into self-help. Mutually exclusive because of the inclusion of an owner's is for an commuter and to enforce. There's nothing to enforce. Thank you, gentlemen of the press.
Well, I will now hand over to my commissioner for information to address you now.
I'll speak loud. Gentlemen of the press, I will not repeat what has been emphasized by His Excellency the governor of Osun State, Dr. Adeleke, play devil's advocate of what they have been saying. Their own argument is that the Court of Appeal is superior to the Federal High Court, and that judgment, the appeal having been allowed, has restored them. Let us go by their own arguments. That judgment, as far as the judgment given in respect of PDP case is concerned, is valid, and that judgment is no longer in existence. There is no argument about that one. rightly or wrongly, the Court of Appeal did not make any consequential order. And the ground upon which the appeal against the judgment obtained by the PDP is that the originating summons with which the PDP applied to the court was incompetent. It disclosed no cause of action. The Court of Appeal did not go into the merit of the case. What was the merit of the case? The merit of the case is the validity or otherwise of the notice given, which the Court of Appeal did not determine. And since there are two separate judgments, one obtained by the PDP, yes, annulled. Another one obtained by the APP. The two parties are different. The two judgments with two different suits. The two suits were never consolidated at the Federal High Court. The Court of Appeal gave the two judgments in different dates. And so the two judgments stand, and from the two judgments, the election were annulled. And the council chairman and the councillor, they were asked to vacate. Now, assuming, going by their own argument, the PDP case and the judgment in respect of it has gone. The one obtained by the APP, and if you could recollect, the APC appealed the two judgments. They did. Knowing fully well, the two judgments as force of law. Looking at the case of APP, they didn't see how they would prosecute the appeal because the APP filed the case after the notice has been published. So they didn't get enough argument to push it forward. So they deliberately abandoned the case. The judgment obtained by the APP, they pushed that obtained by, because they find that this case was actually filed before the notice was published. So if we agree with them that the judgment in respect of the case of PDP obtained by the PDP has gone, the judgment in respect of the APP which they filed the appeal and they abandoned, and the Court of Appeal struck out the appeal, becomes subsisting. You cannot pick and so all the arguments as per the case of a PDP, yes, they are right, but they will always be silent on the case and the judgment of APP, which is subsisting. My learned friend, Honorable Attorney General, said the judgment is a judgment in. What does it mean? The meaning of that one is irrespective of the party in that case. The judgment of the court that sacked them is valid and enforceable. As if because the PDP is not the party there. It's not about who is the party. It's about the that has been delivered by the Federal Court. We want you people to understand this thing so that we are on a fermentary. And let us now see this. Let us agree they now go to two of three things. First and foremost, they will be guilty of disrupting the public peace. Secondly, if they get to a local government and do anything funny there, they will be guilty of destruction of public property. And the third one, they will be guilty of contempt. And we want the whole world to know that they should not test the will of this government. Any one of them that dare and try to go to any of our local government will file of court record. We will now expect them to bring the Court of Appeal, different suits, to come and so we are warning them now, stated by our governor, that we know our president to be a Democrat and somebody who respects the rule of law. We know that wise counsel will prevail.
And I thank you very much for listening. Thank you very much.
ẹ ṣeun o ẹ̀yin èèyàn wa bí ó ti mọ ohun tí à ń sọ nípa rẹ̀ ni pé bí gómìnà bí wọ́n ṣe bá àwọn sọ̀rọ̀ nípa àgbẹ̀ pé kí a bá ọmọ àkọ́kọ́ tí wọ́n ti ṣe fún ìdájọ́ ní ìpínlẹ̀ Ọ̀ṣun ọ̀nà ìbúbadà àwọn náà bá wa sọ̀rọ̀ àti kọmíṣánná fún ètò ìròyìn ẹ̀wọ̀n náà ti bá wa sọ̀rọ̀ pé ká ní sùúrù o bí ohun gbogbo bí ó sì ti máa lọ ní ìrọ̀wọ́rọ̀sẹ̀ rèé títí tí ètò ìdìbò tí ó fi wáyé ní ọjọ́ sátidé gbogbo àwa tí a wà níbi ètò yìí tí ọ̀gá wa àgbà tí wọ́n kó wa ṣòdí akọ̀wé àgbà wa arábìnrin Jọládé Ìgbàwọlá àwọn ni wọ́n kó wa ṣòdí wá síbi Tóyìn Owójayé àwọn wà níbi tí wọ́n jẹ́ ọ̀gá ìmọ̀ ẹ̀rọ bẹ́ẹ̀ náà ni lórúkọ Olúbùnmi Adéyẹmọ tó jẹ́ ọ̀gá tó wà ní ìgbọ́nubé tó ṣe ń jáde àjọ ṣe ètò yìí náà ni Mọ́ránà Adésóyè tí wọ́n wà ní ìgbọ́nubé tó ṣe ń jáde ní tẹlifíṣàn àjọ wà níbí náà ni Tèmítáyọ̀ Fágbọ́n wọ́n wà níbí bẹ́ẹ̀ náà ni Paul Onítì àjọ òǹdé ọlá Àkàndé Samuel Babawale Ṣẹ́wọ́ Òbíṣẹ̀sán Akin Ògúnṣọlá Ayọ̀wálé Atóyèbí Olúwatóyìn Ọ̀jọ̀yẹmí Fúnmilọ́lá Àjòdò ti Dáúdà pẹ̀lú Matthew Agunbíadé lájọ mú ètò yìí wá sétí gbọ̀yìn títí lọ́pẹ́ Àjíbóyè lórúkọ tèmi títí ìgbà míì tí a tún máa múlò ètò báyìí wá fún wa afẹ́ fàyín lé àwọn tí wọ́n ń bẹ ní ìgbọ́nmi ètò ní rédíò Ọ̀ṣun afẹ́ fàyín lé wọn lọ́wọ́ àtàwọn tó wà ní ilé ní 113 Star Times àti 502 Free TV náà ni afẹ́ fàyín lé lọ́wọ́ pé ìpàdé wa bí ayọ̀ bí oyin ó tún dìgbà míì ẹ ṣé púpọ̀.
Ọ̀ṣun kó lè gòkè àgbà. Ẹ jẹ́ kí a ní ìfẹ́ ara wa. Ká sowọ́pọ̀.